for listing of issues. This, if you recall, earlier it used to be T plus 12, that was reduced to T plus 6, and now board decided to reduce it to, in principle, to T plus 3, and using the UPI interface, and with, of course, SBA remaining the concept as it is. So this will benefit both issuers as well as investors. Issuers will have faster access to capital raised, thereby enhancing the ease of doing business, and investors will have early liquidity. The modalities will be worked on in consultation with shareholders, and it will be implemented in a phased manner. Next, I would like to mention about framework for enhanced borrowing by large corporates. You would recall this was a budget announcement for this year, and this is basically with a view to giving a nudge to large borrowers to go towards bond market. This is one of the proposals for deepening of bond market. So this should not be seen in isolation. This should be seen in consonance with various other measures which have been taken in the last few years by SEBI and also by RBI and government. So as far as this proposal is concerned, the eligible borrowers, the large borrowers, the way they have been defined, it's very much in line with what was said in the consultation paper. Just to recapitulate, outstanding borrowings of 100 crore and above, and credit rating of AA, and which they intend to finance itself with long-term borrowings, which defined as more than 1 year of borrowing. As for the compliance for the first 2 years of implementation of the framework, this is proposed to be implemented from 1st April 2019. So for financial year 19-20 and 2021, it will be on comply or explain basis. And this is basically to give them some time to get used to the concept. And from 21-22 onwards, the requirement of 25% incremental borrowing by such borrowers through bond market shall be tested for continuous block of 2 years, and there will be a penalty in case of there is a deficiency in this. Next item I like to touch upon is participation of eligible foreign entities having actual exposure to Indian commodities market in the commodity derivatives market. So this is the first step for opening the commodity derivatives market to the foreign participants. Approved the regulatory framework for permitting foreign entities which have actual exposure to commodities market in India to participate in the commodity derivatives market, domestic markets in India. It defines concept of eligible foreign entities. This issue has been under discussion as to whether institutions should be allowed in commodity derivatives market, and at what pace or in what phase. And earlier the discussions have been on FPI, where they should be allowed. Then there are issues of without underlying exposure that may be speculative. And so this proposal has come about after having discussions with RBI and Ministry of Finance. And what has been decided is that they will be allowed to trade in all commodity derivatives traded on Indian exchanges, except those contracts having underlying commodity defined as sensitive commodity in terms of SEBI circulars. And tenor of the hedge should not be greater than the tenor of underlying exposure. This may be reviewed based on experience of EFE participation. The benefits of this obviously are discovery of current global benchmark prices for some key commodities which are traded only in Indian commodity derivatives exchanges would get strengthened by participation of foreign entities who have import-export business with India. Make Indian commodity derivatives market more efficient, depth and liquidity per month contracts. Next item I like to highlight is interoperability among clearing corporations. For that, amendments required to the security contracts regulations, stock exchange clearing corporation regulation. This is also a concept which has been under discussion for quite some time, and it was discussed, and board approved the proposal. And interoperability among clearing corporations provides for linking of multiple clearing corporations. It allows participants to consolidate their clearing and settlement functions at a single clearing corporation, irrespective of stock exchange on which the trade is executed. It is envisaged that interoperability would lead to efficient allocation of capital for market participants, thereby saving on cost as well as provide better execution of trades. SEBI shall carry out necessary amendments to SCCC regulations and issue necessary circulars, guidelines, inter alia, including inter-clearing corporation margins, inter-clearing corporation settlement, inter-clearing corporation collateral, default handling process, dispute resolution mechanism, and certain technology-related issues. Next item was on proposed Securities and Exchange Board of India settlement proceedings. This, we had set up a committee under Justice Dave few months back to have a relook at the consent mechanism. This is basically with a view to have effective enforcement. This is linked with that, and to see whether it needs rationalization and what all could be considered for consenting, and so that SEBI could focus its attention on important and crucial cases, and it should be seen as a credible action for serious cases, and it should not be, time should not be wasted on the cases which are of smaller nature, and also the cases which could be consented. So broad salient features of these regulations are that board, it is principle based as compared to the earlier regulation, and board may not settle any proceeding if it is of the opinion that alleged default has market-wide impact, loss to investors, or affects the integrity of the market. So this is the guiding principle on which it will be decided whether a case is settleable or not. Then again, board may not settle any proceeding where the applicant is a willful defaulter, a fugitive economic offender, or has defaulted in payment of any fees due to penalty imposed under security laws. A new provision dealing with settlement with confidentiality to any person who provides material assistance to the board in its fact-finding process and proceedings has been specified. So there will be a separate procedure with less penalty for the people who assist in fact-finding process. That is a new clause or new mechanism which is being suggested. And also, board shall not consider an application for settlement if an earlier application for the same alleged default has been rejected. Now, the other item is amendment to SEBI PFUTP regulations and SEBI PIT regulations to implement the recommendations of the Committee on Fair Market Conduct. You would recall that last year we had set up a committee under T.K. Vishwanathan, ex-Union Law Secretary, on this issue, and it looked at both these regulations, PFUTP and PIT, and made certain suggestions. So those were discussed in the board meeting and were agreed to with few not changes, but with few clarifications. And the important one, of course, is that on the issue of use of front entities or mule accounts for engaging in fraudulent transactions and related recommendations on affordability index, it was decided that this matter needs further discussion with stakeholders. On the issue of additional disclosures considering public comments, the proposal for disclosure of name and PAN number or equivalent identification of persons residing at the same address as the designated persons for a consecutive period of more than 1 year, and disclosure of phone, mobile, cell numbers whose billing address is residence address of the designated person, this was dropped. And on the recommendation that SEBI may seek direct power to intercept calls and electronic communication under the Telegraph Act, since this authorization is to be considered by the government, it was decided that the matter may be referred to the government for taking an appropriate view. Next item is common application form for FPIs. So this, in fact, SEBI has been spearheading for last almost 1.5 years with RBI, CBDT, and DEA, and a common application form which has been recently notified by the government has been now brought in, decided to be brought in the FPI regulations of SEBI. And this common application form will deal with FPI registration with SEBI, permanent account number with income tax department, KYC for opening bank account and demat account. So this will be common application form. Otherwise, this was happening sequentially and taking it a lot of time. So this is with a view to having ease of business for FPIs who intend getting registered in India and initiate trading. So there are various other decisions also which are mentioned in the press notes, but I thought I will highlight some of the important which I feel are the important ones. So thank you, and now the floor is open for questions.
Ankur Mishra from Business Television India. Was there discussion on extended trading hours, and is there any meeting called in a week or so with all the stakeholders by SEBI?
So there was no discussion on extended trading hours, and I just want to clarify on this that we have issued a circular enabling. The important thing is that it enables that from 1st October 2018 it is enabled. But the issues of discussion with the stakeholders is for the exchanges to come back to SEBI with a complete proposal, and that includes discussion with the stakeholders and risk management issues, settlement issues, what will be the different slabs in which if it has to be from 9:15 to 11:55, it will be in how many periods and all. So those details are still to be given by the exchanges, and as if when they give, then we will consider. So it is 1st October is the enabling date. It is not a target date, and complete proposals have not come to us, and this matter was not discussed in the board.
Mr. Tyagi, as far as the revised circular for KYC requirement for FPIs is concerned, you said that it was issued separately. If you could give us a sense of to what extent.
So it is largely we have agreed with what Khan committee is saying. Let me say that.
So how will you deal with the fear of alleged money laundering and that route being misused for outside?
So that's why I'm saying that it will be issued separately, because you also know that you have to see the details. So broadly it is in line with Khan committee. I'm saying that, and you just wait. It will soon come. The circular will soon come.
The Justice Bhare committee also. That's
Yeah.
also a very important aspect.
Yeah.
And you've considered some of their recommendations for reviewing the entire consent mechanism.
Yeah.
The Justice Bhare panel had recommended widening the scope of the consent mechanism. And in certain cases, they have said that maybe certain serious market violations like insider trading and a few others may also be considered. Just wanted to get a sense whether the board today has considered serious market violations like that also to be kept eligible for consent on a case-to-case basis.
No, it is actually, that's what I said. It has gone on principle based. So which has market-wide impact, which impact large number of investors, rather than pinpointing which type of wrongdoing or offense. So it is in principle based rather than saying in black and white that this will not be done and that will be done. So that is the difference.
That's the
Yeah.
Chairman sir, Yash here from CNBC. First question as a follow-up to the extended trading hour. Of course, there was an enabling provision from October 1st. We understand that, of course, brokers have also reached out to SEBI, expressed their concerns. Have they sought any sort of time extension from that October 1st, or is it permanently deferred as far as extension is concerned?
No, one by one. You can ask the second question. I'll answer this first. First, I am saying there is no deferment of that, and there is nothing. I am saying it is enabled from that date. Now, exchanges have to come to SEBI with a proposal which is self-contained and contain all the issues, operational guidelines, how will actually it will work, and also in consultation with the stakeholders. Those brokers are registered with the stock exchanges. So if a complete proposal is not there, what does SEBI approve by 1st October? There is no question of deferment or not deferment.
What is the stand which brokers are taking? Have they sought?
No, sought means I am already clarifying that if a complete proposal is not before us, what view can be taken? So let complete proposal come from the exchanges, and then we'll take a view.
Sir, as far as the KYC requirements for FPIs are also concerned, of course, the first time when the draft had come out, there was a requirement of going back and having a further consultation. So in the first go, were there serious loopholes in terms of what you've received in terms of the consultation from the committee now? And could this have been done in the first go itself? Were these that serious?
So I'll tell you what, You know that SEBI has a system of wide consultations, and the intention of the circular was never wrong. No one has said that. And that time actually it was perceived that it's a PMLA related issue. So if something is under parliamentary law and which is not within the purview of SEBI, so it was perceived that perhaps there is no need for consultation. PMLA is something which must be implemented. So there was one confusion which actually broadly I must say and admit that it was that for beneficial ownership under PMLA there is a definition of beneficial ownership. That was clarified by Department of Revenue when it came to our notice. Our suo moto we gave it to Khan Committee. No one has asked us to give it to the Khan Committee. We took up with Department of Revenue as to what is their view, and then they clarified that PMLA definition is for KYC purpose, for reporting purpose. And as far as the eligibility is concerned, concerned regulator could take a view. So that's how it started. There was no intention of not having consultation. Earlier it was, if I may admit, it was simplistic to assume that it is PMLA and should be implemented. So that we realized, and we realized well in time. When we gave it to Khan Committee, we extended also till December. So we gave time, we knew it will take time, and now we have come to some broad conclusion. And PMLA, FEMA related issues are very complicated. It's not something, so it's not purposefully done. It was done under the bona fide assumption that it is a PMLA related issue. So I hope I am clear on this.
So we are based on and I want to know about the corporate governance in Infosys. There have been a lot of reports on fintech, and the reports are not available for the common shareholders. For example, the severance package given to Rajiv Bansal, CFO. There was a report, and what was there in the severance package? Why was given 70 crore rupees for the severance package? We never know. So what is the what SEBI can do in this matter?
So that whatever action SEBI was to take, SEBI has taken. And but that is we examined it. It is internal matter of the company, and whatever action we needed to take, we have already taken. So right now we are not examining any of those issues.
Sorry, this follow-up from business line. So, you in this consent mechanism, you are saying that cases with market-wide impact will not be settled. But sir, this market-wide impact has not been defined, or has it been defined?
No, you yourself say, can it be defined?
So exactly.
It is not.
Leave it open for interpretation of the
No,
case
no,
like
but then if you try to straight jacket is that PFUTP will not be done, and if it is a very simple, small sort of a fraud of say 1 lakh or 2 lakh, and you put your enforcement mechanism with few thousand cases pending in SEBI, that also doesn't make sense. So it will be a difficult call. So that's how we appointed a judge, retired judge of Supreme Court, to actually guide us as to how to proceed. So both ways there is a problem. So but ownership is of SEBI. So don't worry, in case there is any issue, ownership is of SEBI, but market-wide impact, market integrity, large investors getting affected is, to that extent, is to be decided. And if you straight jacket the wrongdoings, that also has its own problems.
There is one more thing. So
High
one
powered
more
committee will take it.
Yeah.
Yes, Mr. Barwa, you want to say that?
Yeah, no, as you know, as per the mechanism, there are two committees, internal and high power committee.
Okay.
So they will take a call on it.
So, but there won't be various kind of interpretations.
No.
I mean, internally there will be some rules that you will follow.
Internally, we'll have some guidelines, and over a period of time, some thing will emerge. It will be more in terms of the experience gained.
So another thing is that as far as you know, we all have known SEBI. There is only two ways for SEBI. Either you reject the application of consent, or you accept the application. There's no rule to return the application. So it has been widely reported everywhere that this NSE's application of consent was returned. So can you throw light on that, whether it was returned or rejected?
It was not returned. They have filed a consent application now, and we'll consider that.
No, earlier also.
I have no idea. I have no idea. You have any idea?
It was returned.
It was returned.
Actually, as per the earlier rule, if there is some other thing is pending, so it has to come together. So they made an application for one settlement, so that was pending, that's why it was returned, it was not rejected.
Yeah, okay.
I have a couple of questions here. As far as commodity markets are concerned, for listing foreign entities, is there a separate classification for foreign investors? So now we are bringing in, because earlier we used to say FPIs.
Right, right. You are absolutely right. It's a new categorization for entities which have actual exposure in the commodities, allowing them only. Otherwise, the fear was that FPIs without any underlying interest, especially in commodities, say agriculture commodities and all which are sensitive. Anyway, sensitive commodities we are not allowing anyway. But without any exposure, if it is only for speculation, even the domestic institutions we are yet to allow, like mutual funds and other entities. So, but this has been under discussion for quite some time with RBI, and RBI is comfortable with this concept. That's how the whole exercise was, to define this concept.
People with exposure to Indian commodities to come in.
Yes.
As I understand.
Yes.
The second thing is that you spoke about sensitive commodities. How many are there in the list? Will agri commodities be part of that, or
You have a list?
No, we don't maintain a list of sensitive commodities per se. Sensitive commodities, we have given a broad kind of definition of sensitive commodities are those commodities which are prone to frequent external interventions, export limitations or stock limits, or those commodities where frequent manipulations have been noticed over last 4-5 years. Those kind of commodities, we identify them as sensitive commodities. So this list, there is a fixed list for that. At any point of time, we identify that this commodity is sensitive or not. That is considered based on the classification.
basically your policy and government policy will go up and down with this basically?
Yeah, those commodities which are prone to be subjected to government interventions or export-import restrictions or stock limits or any other limitations or restrictions put by any external agency. Or for that matter, the commodities which are facing frequent manipulations over the last 4-5 years. So those kind of commodities will not be made available to the EAPs who will be coming to India to participate in this market.
You said that AF category 3 was allowed in the commodity and then with respect to warehousing and other.
Yeah, warehousing.
And other. There was some committee which was formed, which also recommended whether this to be made
Custodian.
custodians,
Yeah.
or you have to have made existing custodians to get into FPI.
So we are examining that. Custodians right now are not very comfortable in dealing with commodities. They have never dealt with commodities, but institutions come through custodians. Even with mutual fund, that is one of the issues. So that we are examining. So that issue needs to be addressed before this gets operationalized. So as far as AIF3, what has been the actual experience till now, I have no idea.
No, there has not been major participation by AF3 because of the same limitation that these institutional participation should be through custodians as per the regulations. So therefore, you have to first sort out the custodians issue, how they are going to participate and enable these institutions to participate to them. So that is where we are working on it.
The final one question on settlement is the other committee. You spoke about settlement with confidentiality. Is there what control to it, or which all cases do you go for settlement with confidentiality?
No, it's not which all cases. These are the cases where any person helps in investigation. So this concept is there domestically in the Competition Commission Act also. So it is partly borrowed from there, and while amending the regulations will bring in various elements. So it is basically whosoever helps in investigation, there should be some provision to give him less penalty as compared to others.
In limits terms, like an approver who's helping you in this.
You are right. In layman, I don't want to use that word. Yeah, it's that.
Universal exchange will start from October 1st. So have NSE and KC obtained approvals to enter the commodity derivatives space?
They have actually applied, and will soon take a view. Both NSE, BSE have applied.
Couple of more questions from our side. Any calculation as to how much savings will this PR reduction will lead to for the industry?
For the industry, for savings, the industries actually will have less, yeah, Madhvi.
Impact on profitability.
Yeah, yeah.
Roughly speaking, we expect that anywhere between 1,300 to 1,500 crores will go back to the investors via various schemes. This is on a base of 13,000 crores of total revenue. So roughly between 10 to 12% will go back to the investors.
One last question on this whole how rating agencies conduct these and rating company from the standard default in July AAA. So SEBI looking at this whole issue as to rating agencies.
So we have tried to rationalize it and we still will further rationalize. In fact, there is another circular which will be issued in a day or two, not related to ILFS, but in terms of composition of the review committee. Whatever we said, that has not been working well, and but it's a thing which has to be constantly watched, because these rating agencies, as to the exact procedure they follow, that is theirs, and we do their inspection, even thematic inspection, but issues keep emerging, and it is for the investors to also safeguard. And this rating agency issue usually also, they say this is our idea. When you ask them, they say this is our view. And mutual funds and all, that's how we ask mutual funds to have their own satisfaction in rating. So that is, but we will constantly try to improve them and monitor them. Vis-a-vis ILFS, I have no specific comment.
बजट फ्रॉम बिजनेस सर, ये प्रस्ताव जिसमें आया था कि डेरिवेटिव एक्सपोजर लेंगे वो नेटवर्क बेस्ड होगा, तो उस पर कुछ बात नहीं आती?
वो मैंने उस समय आपको उसी में बताया था कि वो जो म्यूल अकाउंट वाला इशू था, वो उसी में वो है कि इसके ऊपर अलग से और चर्चा करने की जाए तो बेहतर होगा। तो इसलिए ये निर्णय हुआ कि इसके ऊपर और अलग से पहले चर्चा हो, फिर निर्णय लिया जाए।
Commodities, you mentioned about how custodians, the issue needs to be resolved before we start the derivatives. So now, to that signal that the October 1 universalized exchanges, they may not be able to start because of the fact that these issues need to be sorted before they can come on screen?
No, that's not related to that.
Okay.
It's only for institutions participating in those markets. Commodity derivatives market in MCX and NCDEX are there.
But
So,
NSE
for further deepening is something where this institution should be involved. So that is what is being tried. So NSE, BSE will have the same sort of I believe as the existing system is there in the commodity derivatives exchanges.
in terms of the KYC, the foreign funds, you have also specified the report has talked about RIs. So now if we include RIs, then it again goes back to PML. Then there is a concern, which is the old concern, that there can be money laundering. So there, have you discussed
So let
that?
me, since I said that a circular will be issued soon separately, so it will be better to wait for that circular. But I must assure that the KYC norms which are there in PMLA, those anyway will have to in terms of the beneficial ownership reporting of that 25%, 15% requirements. Those have not been diluted by the committee. Committee is only saying that in terms of the eligibility, they need not be followed. So those concerns will be addressed by the PMLA rules, and whatever monitoring is required, that will not be diluted. But you wait for the.
Idea of how much of money coming through non-residents via these,
No, we have no idea. We have not made an assessment.
and one more on the direct committee, sorry, the Khan committee was passed about high risk decide. So let's say we decide.
That circular will also address. So you just wait. No, on the first one, it will take a little bit of time. Because there are different models, peer-to-peer model, and different other model is where one of the clearing corporations become a clearing member in other clearing corporation. So we are studying various models. Some jurisdictions leave it, they don't make it mandatory. They just suggest, and it is for the clearing corporations to take a view. Based on that, they have an agreement as to what collateral they will have to give to each other and all. We are of the view that should be made mandatory. By leaving it to corporate to exchanges and all is not going to work. We are seeing various models. So in principle, it has been approved, and it will be peer-to-peer model and not the other one. And so we have some sense. We'll try to do it quickly, but let's see how much time it takes. On the ICICI, to my information, some reply has come from the bank and the earlier CEO. So we'll examine that. Have they applied for consent? I am not very sure. Some reply has come, but have they applied for consent? Okay.
Yeah, this is Shrini Chaudhary from Business Standard. I have just one question that the committee has also this time mentioned about not setting any procedure which is where the applicant is willful defaulter or fixed offender. So just wanted to know if in this case, like the cases of illicit offenders, you will take a principle-based approach or it's a complete denial as far as...
It is a complete denial. It is a complete denial.
This is Srikanth from Cogensis. I have two questions. One is about the circular which was withdrawn by SEBI in the past. Banks have to inform within a day on default of loans by the company. And secondly, on whether SEBI has come out with some fresh norms on that, on default norms. And second is that have SEBI received any proposal from Wakarangi about the buyback?
First one, there is no new proposal on that. That was taken to board twice, and there was operational issues could not be agreed upon. So we are not looking afresh for the time being. The second one, what did you say? Vakrangi buyback offer? Is there any buyback offer of Vakrangi?
Open offer is from.
You want to say something?
No, on that we don't have an update. That was an order which has been passed saying that Vakrangi has to make an open offer because of certain violations.
September 23rd is the day when those 45 days will be over, which basically leaves us with only a couple of days. This company has in the past not been very transparent with its disclosures, and SEBI has not apparently pulled them up for obfuscating the cancellation of the buyback and the dividend. Has SEBI taken on that? The companies
Sorry, I am not aware of a specific case, but since you raised, we'll find out and let you know. Aryan, please note down his name and address. We'll let you know on this issue.
So on interoperability, like, will there be discussion on what model will be adopted?
Discussion with whom? It has been discussed. The proposal has come only after a lot of discussion, then also taken to SMAC, and there have been discussion in the last 1 year on various concerns of both the exchanges, which model they want. So it is conclusion of that, and it will be done only with their cooperation. As I said that in some jurisdictions it is left to the exchanges to do it, but we think that that may not work, and we want to address it by saying it will be done, but we will not force something which is not good. Yeah, sure.
And then borrowings by corporates, that's only for listed.
Yeah, SEBI has jurisdiction on listed companies only. Yeah.
So there are certain reports which essentially suggested that another regulator, the insurance regulator, specific things. First one was a diversification of shareholding reservation pattern, that QIB portion reduce that and diversify amongst other shareholders. And the second one was to reduce the minimum public shareholding, increase the time from the current 3 years or reduce the quantum from 25% because they believe that risk, putting that risk in public of an insurance company is too little time, 3 years. Has there been any sort of consultation, discussion, anything?
Not at my level, and so I'm not aware. Have you? So not at our level, not the chairman or members level. So, so that news emanated from where? So you may have to ask them. They could have been at some level, I don't know, but not at our level.
So as far as the NSCI case is concerned, last year you had issued show cause notices to Motilal Oswal, Geo Trade and Philip and Anand Rathi. So has there been any update on the same?
I mean, I think case specific which are pending adjudication with SEBI, it may not be appropriate to discuss them. What I need to say is that those cases are going on and would be brought to their conclusion as early as possible.
Mr. Tyagi, one of the other proposals in the Committee on Fair Market Conduct related to direct power to intercept calls. Now, going by the press release, it says that the board has decided to refer the matter to the government. Now, this is something that has also been thought in the past by some of the predecessors as well. I wanted to know what is your personal opinion on this direct power to intercept calls available to the supervisory. And the second question, if you don't mind, I just want to take off what Tarun was asking a while back. This is in the case of ICICI Bank. It's not about the consent proceedings. It's about something that happened recently at the ICICI Bank AGM, where shareholders were crying foul and they were essentially saying that they openly in public at a function as the AGM of ICICI Bank. What is your take when shareholders are publicly criticizing the bank?
No, let me answer these there. Forget about the first ones. You see, on that issue, the point is that perhaps insider trading, the ones at least which disrupt the market, they are the most serious offenses actually which SEBI could deal with. At the same time, in terms of enforcement of those cases, our progress and actual statistics has been quite poor. There have been, in fact, to my knowledge, no conviction on insider trading which has taken place. That doesn't mean that by getting these powers that will follow, but that perhaps is one of the link in the whole thing. That naturally for insider trading, no one will communicate in writing. It will be only through communication, telecommunication, and all. So that is an idea which the committee, I think, has proposed. And right now, there in the Ministry of Finance, to my knowledge, CBDT, Enforcement Directorate, and DRI are allowed to have this power. But I am equally cognizant of the fact that there are serious privacy issues, and if these powers are to be exercised, they have to be with a lot of restraint, and with exercise with the approval at the highest authority. So I am cognizant of that, but it is referred to the government because of the Indian Telegraph Act. The powers which have been given are by the government.
So even XOC doesn't have that.
So I am not comparing that who has and who doesn't. I have said that we feel, and that's what we thought after discussion when the committee recommended that we should be armed with more powers to detect these, not only detect but also enforce. Because for some reason, if you see insider trading cases, our conviction rate has been not at all satisfactory.
Sir, to make your record healthier, then are you open to this power being available to the I'm just
I think it will be, it will be not proper for me to say because I am not sitting in personal capacity. So SEBI, in fact, we can take it to the board guided by that. And so let's see what government has to say on that. So I think it's time to target WhatsApp also.
Mr. Tyagi, your response on ICICI Bank shareholders review? And the
You
AGM.
see, I mean, shareholders, they are supposed to be the actual owners of the company. If they are dissatisfied, then they should take action and take further action, whatever they have the powers under the Companies Act. I mean, one can't really go by emotion. And whatever was in our domain, we initiated those actions. And if in AGM shareholders are not happy, they should proceed to Companies Act and take it. Bips is for beyond 30 cities. But it should not be that institutions which are located in those cities, they also, for their investment also, they should be charged. This is for retail investors in those areas, in far-flung areas, or not for the institutions which actually know, are well versed with the investment climate and are informed investors. So that is the issue. You have to say something?
Yes. You're right. It would be under the context of mutual funds. It needs to be defined as a concept because it would encompass the asset under management